joining us for the webinar Demystifying Prevention of Sexual Harassment at Work in partnership with KELP HR. This is Saloni from People Matters, and before moving to the agenda of the day, let me give you a brief of the topic. There is an increased need for awareness on workplace harassment, particularly related to gender issues. A clear understanding of best practices will give your HR professionals the tools to make your workplace a safe and aspirational place to work. Prevention of sexual harassment at work involves understanding the legally mandated rules for organizations and also understanding nuances of cases. How should you handle anonymous complaints? What do you do when there is no evidence for a complaint? Can you penalize a witness for not speaking up during an investigation? How does the government track compliance? This webinar will answer the 20 most frequently asked questions. Here's what we'll cover. Understand the legal landscape on prevention of sexual harassment. Learn how to organize a PoSH committee. How to manage high-profile CXO level cases. And how to make the workplace safe. Let me now introduce the speakers for this webinar. We have the privilege of having with us Smita Kapoor, co-founder, KELP HR, and Vijay Hari, CEO and co-founder, KELP HR. Smita Kapoor, co-founder, KELP HR, is an HR veteran and an authority on prevention of sexual harassment at the workplace. She has consulted over 50 organizations and provided solutions for the prevention of sexual harassment needs. She speaks at various forums on the subject and is an influencer on the subject. Vijay Hari is the author of VCC, Behind Closed Cubicles, CEO and co-founder of KELP HR, and specializes in setting up a governance models, prevention and redressal committees for anti-sexual harassment in the corporate world. She is a speaker at several forums on this topic and has conducted awareness workshops across India on prevention of sexual harassment, gender and diversity sensitization. Our partner for today's webinar is KELP HR. KELP HR's flagship offering on prevention of sexual harassment, PoSH, is aligned and designed in order to make your organization complaint with the Sexual Harassment of Women at Workplace Act 2013, Prevention, Prohibition and Redressal. KELP HR has been delivering PoSH end-to-end offerings to clients across India. We have saved time for you to ask your questions at the end of the webinar. For those watching live webinar, you can submit questions at any time during the presentation through the Q&A section. We will try to respond to as many questions as time allows. We have an exciting topic to discuss in this webinar today. So without any further delay, let me invite Ms. Smita and Ms. Vijay to take over. Over to you.
Thank you, Saloni. Welcome all. Very happy to have you all here. This is Vijay here. This is our third webinar with People Matters. So the idea of this webinar is to help organizations get clarity about the law and try to define in between the lines. In today's session, we picked up those specific questions which are either not defined clearly or are confusing us. Smita and I get these questions asked at various forums from various clients that we deal with. We thought best to collate all these questions and respond at a common forum. I'll be posting these questions between me and Smita. Will be handling these questions and answering and sharing our knowledge with you all. So thank you all for participating and the huge response that you've shown. We've been getting a lot of queries even before the webinar. So thank you all for joining, and I hope you'll find this helpful. And please do keep posting your questions. We'll be happy to take it at the end of the session. Can we get started with the survey? I'd like to share the survey that we did last year on prevention of sexual harassment. Yeah, so that is just the gist of all the survey findings that we've done with 22% of victims at the workplace. So I'll move on. So the slide 3 is a quick checklist for you all to take notes on what is required to be compliant with the Prevention of Sexual Harassment Act 2013. So these are the 4 key points wherein every organization has to create a policy and create awareness of the policy to all the employees. And which defines what is sexual harassment, do's, don'ts, where to reach out and raise a complaint. And then to form an internal committee which will help with prevention and redressal of sexual harassment complaints or issues. And number 3, all the cases need to be recorded, documented in registers, and the number of cases need to be reported annually to the authorities. The 4th point is to display posters. This 4th point is a lot of questions keep coming from our clients as to this is mandated, why should we do it, where should we display? This is one key thing which the law mandates, saying that posters have to be displayed in the lobby, in the reception, stating that the organization has zero tolerance to sexual harassment, and where anyone can reach out if they are facing the harassment, the email ID or the number that they can reach out to. It's essential that we post it in the reception because any employee who walks into your organization has to be protected, be it even a pizza delivery person or a courier person needs to be protected and needs to know where to raise a complaint. Hence, it's required that we post it in the lobby. Slide 4 is about the question and answers. We're starting off with all our questions. Why only women are covered as part of the act? Why does the law not protect the men? Whereas in other progressive nations, we do have gender-neutral laws. Whereas in India, very specifically, right from the Shaka guidelines from 1997, we've been talking about protecting only the women. The answer is, one is to do with the patriarchal society that we are from. And given the fact that the majority of the cases, the victims are women, and hence the government at least ensure that in the workplace women have to be protected. That's what the law says. So there's nothing stopping the organization to extend the law and make it gender neutral. So it's just an extension of the law which will protect, and that's something that we recommend all the organizations to have it. And so 90% of our clients go with a gender neutral law, policy, gender neutral policy which protects both men. And having a gender neutral policy helps in getting the buy-in from the men folks as well. Okay, there are some organizations that are very specific about regulations and complying with exactly with the law. Those organizations, they do have it as a women-only policy. And any cases wherein their men folks, if they raise a complaint on sexual harassment, that will be dealt as part of their code of conduct or disciplinary action. It's not that they don't deal with it, but definitely yes. So I'll move on to slide 5. Is IC needed? As per the law, it very clearly states that any organization which has more than 10 employees have to form an IC, and it has to be specific for every location. There should be a separate IC formed, right? So this is again a very oft requested question. So yes, very clearly law states that IC is required even if it is more than 10 employees. Any organization, be it organization, institution, hospitals, any form of employer with more than 10 employees need to have this IC committee formed, even if you're an all-male. The reason is, again, to protect any women walking into your organization or into your premises. I'm sure even if it's an all-male, you'll be dealing with vendors who are women or clients who are women or even housekeeping staff or be it anyone interacting with other women folks. So even they have to be protected, or something that the law has clearly states. Anyone in your premises, any women walking into your premises have to be protected. Hence, compliance to this law is required. I'll move on to slide 6. Anonymous complaint and secret identity. So again, a lot of people ask, how do we handle anonymous complaints? Should we really take it up? Anonymous complaints can be of two types. One is a complaint with no details, which does not have any specifics. So those can be definitely ignored because you definitely don't know who it came from or what action to take. But if an anonymous complaint has all the details and the specifics of the incident, the people involved, the time, the witness, if it does have those details, it is definitely worth taking a look at it because at least some prevention measures can be taken based on these anonymous complaints. And the reason why employees or anyone is raising an anonymous complaint is one, they are afraid. This is a sensitive topic. People are embarrassed or they are afraid that they may lose their job or probably the trust in the committee, they've not yet developed that. So probably acting on these anonymous complaints and taking some measures probably enhances the trust. Okay, so definitely in some of the organizational cultures where it is a very traditional and all those things, so we definitely say that we recommend having a complaint box or suggestion box where it's easier for employees to drop even if it's an anonymous complaint. Because approaching the IC and talking to them about these sensitive topics can be embarrassing for people. So anonymous is something which will help us to take at least preventive measures and provide a safe work environment. And does IC give away the identity of the witness? This is something on need-to-know basis. It's completely with the organization, and you have to ensure confidentiality is there. The case needs to be discussed only on need-to-know basis. Give only the information that's required for who are the parties involved. No proof. What do we do when there is no proof on the cases? Let's take a simple example of a complainant, a victim, and a respondent. So the complaint comes in saying that I walked in the list when I was coming up, person ABC slapped me on my back. And this is something that I cannot tolerate, and there's no proof to it. So what do I do? So this is something again, a common case where sometimes there's no proof at all, or probably a one-off incident where the victim does not want to live with it, and hence they are bringing it to the IC's notice. In such cases, we try and identify any form of evidence, witness. We try and figure out if there was a security guard outside the lift who noticed something wrong when these people walked out of the lift, or was there a CCTV camera which captured at least a reaction when people walked out of the lift. So that's something those are some of the things that we can verify. But in all cases where there is no evidence, the law again very clearly states no action can be taken when there's no evidence at all, no evidence of witness. So in such cases, what we recommend is that the very fact that the lady or the victim, be it a man or a woman who has brought it up, we do give some benefit of doubt to the person who brought it up, and to the respondent, the only action that can be taken is we put the person on observation. So we cannot really take an action or give penalty on that because there's no evidence, there's a lack of evidence over here. And it depends on the severity also. So if it's a minor case, then we just put the person on observation. The other further cases probably we could do is, if it's a serious case, then we separate these two people they probably are not in same reporting relationship, or probably they don't have to face each other at work. We put them in different floors or different shifts, whichever is possible. Smita, do you want to share your experience on slide 8 on how do you guarantee the confidentiality while dealing with cases?
Sure. Confidentiality is very key to any IC. IC as a committee and also sexual harassment cases. It is very, very important for us to ensure that we maintain confidentiality about the victim, about the witnesses, and also the respondent till he is proven guilty, right? And also beyond it. Anybody would get to know about a case which is going on within the organization only on need-to-know basis. Even when we conduct IC sessions and we take the NDA from each and every IC members within the organization. They have to sign an NDA, and in that they have to declare that any information will not be leaked, even to their bosses. It is a very common trend that the bosses of the IC members are very curious. Even the owner of the company or the CEO of the company or the board of the organization are very curious if there is any sexual harassment case going on. So they would call upon any IC member to discuss. So this is what we drill in our training sessions, that confidentiality is key. Now, how do we guarantee this? We have to ensure we take an NDA, as I mentioned. We have to create awareness about why is confidentiality important. There are times where a fine is levied on people who leak or who breach confidentiality. Okay, I was reading a recent article where up to 5,000 rupees of fine has been implied. So these are some things that we can do. We can do many more things. That whenever the victim comes in, we have to explain to her the entire process, that how it will be taken care of, how her confidentiality about the whole case will be maintained. Witnesses, we will ensure that they are taken care of. We tell them that if you are found speaking about it, in any of the water coolers or it comes to us, it will be taken very severely. So there are these conversations, awareness, but still, if there is a sexual harassment case, we see people speaking about it. So this is for us as an IC members and HR to ensure that we mention this in Code of Business Conduct and various other documents, and tell them how important is confidentiality, and especially in the case of sexual harassment. It is not something that we can speak about everywhere and anywhere. The next one, knock, anyone monitoring. Now, what happens is we come from a typical Indian mentality. Till the time we are not asked what are we doing, we do not follow many regulations, right? In fact, Vishaka was launched in 1997. How many organizations were compliant to it till it became law and an obligation of every organization to ensure that they are obliging to this law? So likewise, there are annual returns that every organization are mandated to be filling in and submitting to district officers. Every year they have to do. How much, they are being monitored is still a question mark, but that doesn't give you escape route not to do it.
The annual return, so there's two places to file the annual returns. One is at the end of every financial year. This is something that people don't really are not really aware of. At the end of every financial year, when the IT returns are being filed, there is a director's report in which there is a small paragraph which asks about compliance with prevention of sexual harassment, the number of trainings, number of cases that came in, number of cases that are closed, and number of cases that are open beyond 90 days. These are some of the 4 points that are asked in the director's report, and this goes to the registrar of companies. So do talk to your CFO or with your auditor of your organization, and usually the IC presiding officer should pass on this numbers to the auditor or the CFO for the financial year IT returns filing. And at the end of every calendar year, between Jan to December, at the end of December, again the same core data has to be documented, printed on a letterhead, and should be sent to the district collector officer. So that is something that, and another copy should be filed in your record as well. So this is tracked by the district collector of every district, and it gets collated and sent across to the National Commission of Women. And that overall collated number is actually reported and collated and shared in the annual report of NCW website. So if you all log into the WCD website annual reports, you can see the numbers that are reported across India for the last every year-on-year record is there, and the number kind of shows that around close to 500 complaints was reported in the last financial year. And so in this 500 numbers, 89 came from Infosys, 118 came from Wipro, and the other companies were the other lot. So the numbers being reported is very minimal, whereas you see the same numbers, compare it with what's happening in the US, In US, you can see that around close to 27,000 cases were reported in the last financial year. So that is the gap that we are there. So it's something is essential that we all start reporting these numbers consciously. So we have an expert. Who could be a third party? Is it only an NGO or could it be anyone else? So this is another of a confused point where people assume that it's only the NGO or a lawyer who has to be a third party. The law very clearly states, A, it can be an NGO person working for the cause of women. B, a legal person who knows the law. C, it could be anyone working for the cause of women or who is aware of the law and is, believes in this cause. So that is where, as Confidentiality, we all come into the picture where we're not part of the NGO or the lawyer, but we bring in the aspect of having known the law and having worked with a lot of organizations. We bring in the people aspect to it and having known the business. So we bring in that angle in helping solve the cases. And why is it essential to have a third party? Of course, to bring in a fair and an unbiased hearing. And it's essential to have a very strong third party. This third party person plays a very crucial role and makes these spineless. The very reason that in case any complaint comes in against a senior CXO or a senior member in the management, it is the third party who is not afraid of losing the job. Whereas the other IC members who would be juniors to the management team are definitely scared to handle such case or definitely scared to question and do a thorough investigation. In such cases, the third party definitely plays a very strong role and they bring in their experience from other organizations. So it's essential that you have a very strong third party. And how many times to conduct awareness sessions? This again not very clearly mentioned in the law. It is very specific to every organization. You can take a call depending on your culture that you want to set in, the message that you want to communicate to your employees. So at the time of induction and probably recap year on year or once every 6 months, share some case studies on this, or maybe during your town hall, get your CEO to address on this 2 minutes emphasize on this particular topic. It's also good enough. Our post is essential. I think we've addressed that already. Yes, it is essential. And IC members to be trained, definitely yes, they have to be trained. It's something that the law again states is mandated for IC members to be trained. They need to know the importance of their role, the responsibilities, and how to go about investigation, and the importance of documenting and writing the reports and recommendations. Yeah, I'll move on to the next slide. Okay, something is brewing. We all know, as an IC member, one of our role is not just handling complaints, but also prevention is a key. As an IC member, if something comes to our notice that some case is happening in a particular department, or there is a victim who is not willing to raise a complaint, so how do we handle such case? Because the law very clearly says that there has to be a written complaint, and that too from the victim. In such cases, what do? There are a couple of options, because prevention is again a key for us here. So as IC member, if you get to hear or the HR hears, they can step down from their IC position and they can raise a suo complaint. Suo is on behalf, or they are raising a self-complaint in order to prevent a particular issue. Okay, so that is definitely possible when you have enough proof, when you're clear who the victim is, when you know what the response, you have evidence and all these things. Definitely a suo complaint can be raised and action can be taken against the perpetrator. So that is an option, so which you can put as part of your policy. So this will definitely send out a very strong and clear message to the organization that such harassment will not be tolerated. Will IC be held against for investigating a complaint without formal written complaint? You definitely need a written complaint. Without written complaint, only preventive measures can be taken until unless you do a suo complaint, which is also valid. So I'll move on to the next question. You follow and we lead. This is again a very common question where organizations, they have smaller branches probably there is a head office with a large number of employees. There's a smaller organization which has only 10 to 15 employees where you would have a senior women working there. So the dilemma is how do they handle, how do they create, I see, such branches? So, or even their entire organization probably do not have any senior, probably even are in the junior level. In such cases, law again states that a senior woman can come in from the organization or one of the sister concerns or one of the subsidiaries as well. So in all such cases, when you still don't have a senior woman, and essentially you have only senior people who are mature enough to handle the case, so you definitely cannot go and put someone junior down the line as part of the presiding officer, because it's a very important role. In such cases, it's completely unavoidable. You don't really have an option than have a male as the presiding officer, but ensure that you have a strong third-party person who's a female and people can reach out to. Yeah, and document the reasons and state it and record it as to what is the reason for having a male as a presiding officer. And I'll move on to the next slide. A breath of fresh air. It's been 3 years since the ICs were appointed. Can the same IC simply resign and get reappointed? This is again a question that people are asking as to. The law very clearly states every 3 years the entire IC has to be rotated, including the third party. Right? So what is the idea of doing this? The idea is that a newer team, a newer presiding officer, a fresh presiding officer brings in a breath of fresh air and a fresh ideas, and probably they could look at perspectives of bringing in a different preventive measure. So that is the idea. Or probably in case if employees are scared to report to the previous IC committee, probably bringing in a new IC committee could lead to bringing out more ideas or bringing out more hidden incident cases. And hence, this is something that's recommended that the entire committee has to be revamped every 3 years. This does not mean that you let go of all the experience gained from the previous committee and the entire committee should be new. Look at rotating the team every year, look at letting go one person and adding a new person. And the people who have moved out can definitely be still part of the committee, and they may not be part of the core committee, but definitely they could be providing counsel to the committee. No obligation. What happens if the respondent refuses to comply with the final action plan? So, in such cases, understand as to why the respondent is refusing to complain. One, is that is the respondent not happy with the recommendation? Does the respondent want to appeal further? If that is the case, guide the respondent to appeal further. If not, if the respondent simply refuses, does not want to oblige by the recommendation given, depending again on what the severity is, probably a code of conduct or disciplinary action can be taken based on the code of conduct, because the person is not really complying to what the committee has given. Right? Next question, can IC register a police complaint? IC can register a police complaint and has to register a police complaint for all criminal cases in case there is a physical injury or if it's a rape, then definitely a police complaint has to be filed by the IC. It cannot be dealt within the organization because IC has only civil powers. We do not have the powers of handling in criminal cases, and a rape or a physical injury becomes criminal offense. Can victim register a police complaint? Victim has all the rights. They can still go ahead and register. They can, under section Indian Penal Code section 354 or 509, they are free to walk into the police station and register a complaint with the police. And simultaneously, a case can also happen. If it's a civil form of case, then definitely a victim can also file a case with IC, and both cases can happen parallelly. Expensive action. As an IC, when do you generally recommend the perpetrator to pay a compensation? How do you arrive at the compensation amount? So, the law again very clearly says the financial penalties can, at the time of reconciliation, there cannot be any monetary compensation, but only at the final recommendation stage, a financial or monetary compensation can be recommended. And this amount is typically calculated based on the loss that the victim faces. if the victim has undergone some loss of pay or a loss in promotion, or the victim has to undergo some treatment with a psychiatrist or because of some mental trauma, so the amount lost by the victim is calculated with interest added. So that is what the perpetrator or the harasser has to pay to the victim as part of the compensation. And if the person refuses to pay this compensation, the IC has the power to even recover it from the salary of the harasser, salary or the full and final settlement of the harasser. The law has even given the right that this IC has so power, they are empowered in such a way that they can even attack the property of the harasser in order to extract the compensation. So I will move on to the next slide. I think I come to an end of all the FAQs. I think a lot of questions are coming in from the audience. So we'll move on and start taking these questions from the audience.
Thank you, Smita and Vijay, for the great insights. Meanwhile, you can provide your feedback in the survey link provided in the chat section because your input matters. We will now move to the questions from our listeners. So here we can see a lot of questions being asked. So I'll take the first question. That's from Karthik from Ford, and he asked that would like to check on how the case closure is handled with respect to going back to the complaint post the action is decided against the respondent. Is it mandatory to keep the complaint informed on the action?
Yes, the law mandates that both the parties need to be informed of what action is being taken. That's something very much essential thing which a lot of organizations are missing out. So very clearly law states that within 90 days a case has to be closed, and within this 90 days, a lot of organizations, IC does take the action, they do the recommendation and all, but they fail to inform both the parties involved. So what happens is the victim is clueless whether the organization acted on it, on the complaint or not. So the trust in the organization is lost when that does not happen. So it is very essential, and law very clearly states both of them have to be informed on what the actions have been recommended or what action was taken as part of the complaint. So this is essential. So based on the recommendations, either the respondent or the complainant, they can decide whether they want to appeal further, right? Because that is another option which the law provides.
Yes. So we have other questions. So that is, in the PPT, it was mentioned that harassment occurs everywhere, including social media. What are the actions that falls under the category of being harassed at social media?
Primarily social media, also if it is part of your workplace, falls under your workplace. So sexual harassment at workplace also covers social media. Okay. Now, important part is who is the harasser. If he falls under the bracket of the employee, okay, and this has happened within that during the office hours or outside of office hours because of the relationship of employee and employee, because of the relationship of being colleagues, then this falls under Prevention of Sexual Harassment Act. Okay, am I clear?
Okay. Yeah, I think it is quite clear, Smita. And let's move on to the other question because we have a lot of questions. We'll try to take maximum of them. So the next question is, according to an HBR report, most women fail to complain because of the fear of consequences of their job. So what steps probably HR organization to build a culture of trust and motivate them to raise their voice?
So, very important, Reshma, that's a very great question, whoever has asked it. And trust me, we come from a society where women have been suppressed for a really long time. It will take a lot of courage for us to speak up for our rights, including sexual harassment at workplace, okay? So, the culture is driven from top. How an organization portrays itself, how open an organization is, what are their value systems. I recently was investigating a case in a very huge corporate setup where it was their first sexual harassment case in so many years, okay? And they had just implemented sexual harassment at workplace. The outcome of it, they took, okay, and they published it across saying that organization has zero tolerance for sexual harassment, and if any victim feels slightly harassed also, the respondent will be taken to task. Okay, we do not have any tolerance. So zero tolerance is something that they speak about, and the value of the organization should be strongly built in, should be showcased in various ways, create awareness, caselets be released for people to read and believe in, then women will come ahead. Okay, if they have seen that there are consequences if I complain and I could lose my job, then definitely women don't come ahead. It is very important that such initiatives should be driven from top very clearly.
Okay, thank you, Smita. So let's take another question that's specifically for the men now. So talking about sexual harassment faced by the men at organization, do you have any statistics with you about the percentage of men who face harassment at workplace and the problems they face in the filing of the complaint and in the investigation?
If you look at our survey, Reshma and participants, members here who are listening to this, we did that survey in 2016 that said out of, I think, a small number, 5% of men raised their hand saying that, yes, we were sexually harassed. Again, we come from a background where men always had an upper hand. So they are very shy to register the sexual harassment complaint. And I say this very openly in a lot of my sessions, right? Men feel that it is a sign of weakness if we say that we were sexually harassed. So that is another coaching that we have to coach our men that it's okay. Okay, nowadays women are in powerful position. You have to accept that first. Okay, you could be harassed, you could be subject to harassment, to accept that and speak about it, because we want to end this even from our society, and we need all hands, right? We need women to raise their hands, we need men to raise their hands. So again, a lot of building of culture is needed. CalpHR is constantly working on diversity as well, so to create that awareness that let's accept ourselves first, and then we should be able to raise such issues and not stop ourselves because of our own notions, because of our own biases, that we cannot do a particular thing. Men face a lot of issues, as in first of all, their colleagues ridicule them. Okay, they are sniggered, they are talked about, they are bullied. So yes, men face issues, but again, as an IC, how strong you are, as an IC of the organization, how strong they protect their men, how strong they protect the identity of the people who have raised such harassment cases, that all needs to be taken care of. So we need very strong work happening from the top, and as well as the IC organization.
Okay, thank you, Smita. I think this was quite insightful, and so we have another question coming up. That's from Gunjan. He asked that if a person file a complaint without having evidence, how will you investigate the case?
Can I rephrase that? Does that mean that if a victim doesn't have an evidence, how do we investigate the case?
Correct.
Around 40% of our cases that we get are behind closed cubicles, as Viji's book names it, right? I think she was inspired by the same thing, because this happens within the closed doors. It is very, very difficult to get evidences and proofs. Does that mean that we do not encourage our victims to raise cases? No. It doesn't mean that. It means that we have to encourage our victims that even if you don't have proof, they have to register case. Gets very, very difficult for IC. IC always in their training program, awareness program, say that if it is not one-off case, please see if you can gather evidences. Okay? Unfortunately, after doing all that awareness also, people come to us saying that we do not happen. This was a one-off case which happened behind closed doors. Then we look up the past records, we look up the behavior of the person, we speak to other people around, some witnesses whom maybe the victim has not listed. So we speak to people around and gather some evidence. Based on that, we take action. But again, there are many cases which go clarified, which is proved, which cannot be proved. So we have to close it, but we separate their working relationship. So the victim and the respondent do not work together. So we try to clean that up in that way. But yeah, we are struggling with it, with not having evidences. So we go with the flow and ensure that, again, we use it as aspect of training people, coaching them about sexual harassment, making them aware about their rights. So we are dealing with these cases in such ways.
Thank you. Now we have a question from Leonard, and he asks that in case of anonymous cases, if there are no proofs found but the case sounds genuine to the IC, what can we do in this case?
Yeah, I think we already took that as part of our slides. So just handle it and probably preventive measures can be done and at least figure out if something is happening without any evidence, we cannot really do. And maybe share the case outputs or the steps taken as a case study to the entire employees. People are aware of what the outcome was.
Thank you, Vijay. So another question is, what about in case of startups where there are maybe 5 to 7 employees and no separate person or HR or director? What if the founder itself is a perpetrator, or what kind of complaints can be filed and with whom? The question is asked by Sangeeta.
Sangeeta, very clearly, National Commissions of Women are working very strongly on this. I don't know if you heard about SheBox recently, which came up on 7th November, the launch of SheBox happened. We can send you a link of that where a complaint can be registered. Secondly, you can always approach LC, Local Complaints Committee, which is commissioned in the district office. Write to me one-on-one. We will send you where all you can, approach this. Please do not let it go, because if you have a perpetrator, not only within your organization, but he is within the nation, and we need to weed him out. Yeah. You have seen the viral fever, you have seen Tehelka, these were all founders of the organization, right? We do not want one more such case. He needs to be weeded out.
Yeah, and definitely something that people should understand is that even if it's a small organization or a large organization where people are heavy, it just takes people's access to social media is at the fingertips for employees now. So when something goes to the media, that's what happened in the case of Uber and TVS. Susan Fowler just wrote it as a blog and posted it, and we saw the repercussions out of that, right? So employees and HR should be aware that social media grabs such headlines. So it's essential to protect the brand image, and we provide a safe work environment for all our employees. Compliance is key.
Okay. Thank you, Vijay. And we have another question coming from the same person. Like, if the employee files an FIR, can the perpetrator file defamation case against the employee, or how can the employee safeguard herself in such cases?
Availability of, any authority, anybody can go outside and file whatever kind of cases. But when a victim files a case, the principle of natural justice is followed. They have to justify from both the sides. The victim as well as the respondent has to justify their case. They have to produce enough proofs and evidences. The case will be heard from both the parties, even in IC, even outside of your organization at court. Yes, there has been cases where respondents have gone ahead and filed suits against the victim, also against the IC of defamation. And the outcome is still out. I'm waiting to hear at least one outcome coming out of it, but we have to live with it. That doesn't stop a victim from not filing the case. Vijay, do you want to add anything to this?
No, I'm good. So definitely police is an option to go. So they have enough evidence, proof, and get in the police station. And if you think this is actually obtained, please do that. The other option is SheBox, as Smita said. That's alternative.
Thank you. Yeah. So thank you, Vijay and Smita. So honestly, there are a lot of questions. We'll surely take all the questions offline. Still, we'll try to cover a few more questions here. So the next question is, can anyone outside organization report the case if victim is not able to report the case?
There are reasons why victim wouldn't not be able to report the case. Either she's physically incapacitated or mentally incapacitated. So there are lists of people given in the law, if you look up the law, who can report on her behalf, her friend, her family member, her legal lawyer, psychiatrist. So any of these members can report the case on her behalf, but they have to explain that why they have done on her behalf and go to IC. So if it is because of physical or mental incapacitation.
So otherwise, the victim is just embarrassed or is just a fear, then probably for someone else is a witness, if someone else is raising, the organization can take note of such complaints and probably coax and try and build the trust with the victim to encourage the victim to raise a complaint on behalf. If not, if there's no written complaint directly from the victim, then only preventive measures can be taken as part of the law.
Yeah, we'll move on to the next question. So the question is, could you clarify on how to handle complaints involving different countries? Should the place of complaint or the place of the incident be considered?
So a very good question. In such cases, look at where the incident occurred and where are these employees belonging to. So if the employees are belonging to India and they are India hired and they are deployed somewhere, also understand the local laws and the seriousness of that, the severity of the issue, and action can be taken accordingly. So if both the employees are your things, then you can get involved and you can give the recommendation based on our Indian law. But if something is serious or something relating to criminal or those things, understand the local laws also and act accordingly. And if there's parties involved, one from India and one from, let's say, with a customer from a different country, then a case has to be handled in both the locations and involve the customers, committee as well, the core committee or their HR, and handle the case in both the locations.
Yeah, thank you, Vijay. There's one more interesting question coming up. So that is, there could be one associate who must have been terminated because of harassment in one organization and joined some other organization and again involved in harassment. Do we have any law for repeated offenders?
Very good question again. I mean, the question says the person was terminated earlier. So termination, I'm not sure whether they intended termination or was probably asked to resign as part of such a harassment case. So there's a difference. With termination, it is a black mark and the person is already harmful to the society and hence the person is being terminated and the career is kind of ruined, right? So you typically would not have hired such a person who's actually having a black mark. Okay. If not, if it is the other case where the person was asked to resign in the previous organization, see, the idea when the person was asked to resign was probably the person is being penalized already and probably the person was counseled and it's expected the person reforms and moves on in his life and joins and gets along in the career. So that was the idea in the earlier organization. And the same thing has happened again, and consider all the other factors and what is the context, what is the severity of the issue, and depending on that, a stronger action can be taken or probably, it is case to case, you'll have to take a call according to that. And the law again very clearly states, considering the past cases and all those things, so we don't want to judge people based on past cases. Okay. So that is something, a last factor that we always look at if there was a past case before we do any recommendation. That will not be a deciding factor at all. But definitely actions have to be taken based on the severity and the context in which it has occurred.
So there was this interesting case where there was a perpetrator I would want to share, and he had committed a sexual offense. So we were in discussion as an IC member. I was as a third party. I was part of this, and where I was recommending them not to terminate his services and coach him. Okay, because we all come from various backgrounds in India. We come from various backgrounds, and many a times we are not even taught how to deal with women, right? So it is very important that some people are coached and trained in how to, and not throw that bad apple out back to the society who's not coached, trained, but he's rotting already and will further rot. So this was my thought process, but the organization was very clear that I do not want this rotting apple within my organization. What happens to him outside, I do not care. So these are the instances where then offender keeps, he doesn't know how to handle. Maybe he has learned his lesson by being terminated once, but I strongly feel that if you have such perpetrator whose behavior could be mended, please mend his behavior and coach him over a period of time before sending him back to the society. Okay, so this is something that is, not quoted in law, but this is something which we share out of our own pure experiences.
Thank you, Smita and Vijay, and I think we should take one more last question. So the question is very interesting. So the question is, if a relationship has gone sour and the complaint has already taken it up externally by filing an FIR, is it mandatory for the company to take it up proactively and take the case further? This is a personal relationship gone sour and no effect on work.
For IC to take up any case, you need a written complaint from victim as per law. Okay, so if victim has filed a complaint with you and also filed an FIR simultaneously, IC will have to proceed with the investigation. So you have to do a parallel run.
In this case, it was only with the FIR and not with the IC.
Okay, so then it is an IC's prerogative what they want to do. As per law, clearly we need a written complaint from the victim. But this is as per law. What would I tell you from my pure experience is that there are many organizations I work with who look at the cases which are not maybe complaint. You don't have a written complaint. They call the victim and they ask them to write a complaint and give it to them. There are instances when that also doesn't happen, so they do a suo motu. Okay, there are organizations which do that. Okay, so it depends from organization to organization what they want to project. As I said, the value runs from top. So what do they want? Do they want to just shake it off and say, not my problem? Again, it is their value that they are promoting. So completely depends on organization and on IC.
And on a added note, it's not IC, it's always HR can always get involved, and as employee relations, because one of the employees getting impacted, there is a case going on, of course the productivity of the team is going to get impacted, the brand image of the organization is going to get impacted because FIR is a public document again. So definitely it's not the IC, HR can get involved and take required action, or at least ensure that these two employees must leave or have a cordial, their work does not get impacted, do not see each other. Those kind of actions can definitely be recommended.
Sure. Thank you, Smita and Vijay. It was quite insightful. And with this question and answer session, we are going to wrap up today's webinar. We have many more questions coming in, and due to time constraint, I would request the speaker to take it offline. And once again, we thank today's webinar partner, Kelp HR. Our special thanks to our speakers, Ms. Smita and Ms. Vijay, for this webinar and invaluable information that they have shared with us today. I would also like to thank everybody in the webinar audience for participating in today's presentation. Stay tuned for many such exciting sessions. That concludes today's webinar. Thank you and have a great day.
Thank you, Reshma and Saloni from People Matters. We really enjoyed the session and answering all the questions. Note to all the participants, the recording of this webinar will be shared in another couple of weeks' time. And all the questions, FAQs that was not answered, we will take a week's time and respond it to each of you. Or we'll share it as a blog and share it with all of you. Thank you so much for all the responses and support that you've been giving us.
Thank you. Thank you so much, Smita and Vijay.
Thank you. Thank you. Thank you very much.